For it. Okay. First bill on our, are we up?
We are now live.
Meeting on March the 2nd, 1:09 p.m. I want to thank everyone and make sure I haven't missed anyone. I see um, Delegate John Carden,
Chair Phillips,
Delegate
your
Frank,
connection.
Delegate.
Oh,
Go ahead.
your connection's not great. Your voice is there's like a echo or something. I don't know.
Okay, I'm going to
I'm
try this one more.
sorry.
I know, no. I'm going to try this one more time.
Okay.
I'm going
It's
to
it's
I'm going to
fine right
drop
now,
out.
actually. It just wasn't a second ago, but it's
Is
fine.
it okay right now?
Now it's great. Yep.
Okay, all right. So once again, I want to go down and say who I believe I see, and if I miss anyone, let me know. Delegate John Carden, Delegate Frank Conaway, Delegate Elizabeth Embry, Delegate Susan McComas, Delegate Gabriel Marino. I do not see Delegate Congolo, Delegate Jamila Woods, or Delegate Lauren Aricon. So did I get that right?
Yes.
Okay. And so we do have a quorum. So this is the Criminal Law and Procedure Subcommittee. We are meeting today to hear three bills in a work session: House Bill 336, House Bill 450, and House Bill 566. We're going to begin with House Bill 336. Is the sponsor of the bill available, and anyone else that is signed up for House Bill 336? Theo, if you could let them into the work session. Welcome, Delegate Addison.
Hello, how are you?
Excellent. Excellent. Welcome, Mr. Giordano. Welcome, Ms. Ruth. And welcome, Ms. Jordan. Do we have anyone else that is joined? I thought we might have someone from the ACLU.
I think she's in the waiting room.
I'm here. Good afternoon.
Okay.
And who was?
Hey.
Could you identify yourself?
I'm Minette Emanuel with the ACLU of Maryland, and I think we also have Elizabeth Hilliard with the Office of the Public Defender in the waiting room as well.
Thank you, Ms. Emanuel. And as I mentioned earlier, you didn't hear this. Unfortunately, I'm having some tech difficulties, so I am on my phone, which limits what I can see and the folks that I can see. Okay. So what I'd like to do, I'd like to start out with the bill sponsor and perhaps the representative for the Baltimore City State's Attorney's Office to discuss the amendments that you all are proposing on this bill.
Good afternoon. Go ahead. You want to go, Hassan?
Absolutely.
Good afternoon. So I went over some of the amendments that was given to us, but what we had already discussed, the state's attorney office and Hassan, one of the things that we wanted to do was we wanted to keep the up to 72 hours. That's what we're asking for in the amendments. I don't know if you, Hassan, had any other amendments, but that's the amendment that I like according to what I had from Miss Lisa Jordan.
Mhm.
Yeah, and so also I did submit something that came from the judge's office from Judge Morsi. He provided a chart for me with these, with the data and also a letter as well. And I know I sent it to Scott and Hassan.
And delegate and for delegates, thank you, Mr. Chairman and members of the committee. So to keep the law simple, of course, we copied the language.
Very good. Mr. Giordano?
Yes, sir. Can you hear me?
Yeah, I think for me, you froze.
Okay. Can you hear me, delegate?
I
We
can't.
can. You
Okay.
froze for a moment.
Okay. So we kept with the language from 2608, putting it here as 2607. The amendments were, as Delegate Addison suggested, that we would, one, allow for understanding and speaking with Ms. Ruth and Ms. Lisa about making sure that district court commissioners have the ability to issue summonses across the board. Didn't matter the subset, whether it's any crime, doesn't matter. We also listened to Judge Morrissey and their concerns in regards to 6-2, which is if an application for a statement of charges is filed by an individual who is not a police officer, state's attorney. We included government investigators and bailiffs in there because they explained to us that they are at times necessary officials that need to file these things. We had no problems with them in those amendments if they chose to include government official investigators, bailiffs, and correctional officers who do at times need to file these things without having to go through the process of the average individual, just like they would be law enforcement. But what we will be doing is summonses across the board, but in issues of defined in 4-501 in family law, domestic violence related cases, they would go to the state's attorney's office, who would then have to make a decision within 72 hours to be submitted back to the court commissioner for a warrant and or summons to be issued. And we took away the 3-year criminal penalty. It took it down to a year.
Okay, so state's attorney would review within 72 hours all warrants and summonses.
Just warrants.
Just warrants.
Yes, sir.
I'm sorry, because they will have the commissioners will still have the ability to issue a summons.
Correct.
Okay. All right, so the amendments that are coming from the bill sponsor, Miss Jordan and Miss Ruth. Any comments from you?
I feel somewhat constrained. And I just want to be clear that when we finished the phone conversation that I was on with you, Delegate Phillips, and the others from the state's attorney's office on that Monday night, there was the clear direction that we were going to have further conversations with the state's attorney's office, which we never had an opportunity to have. And so the state's attorney's office has not responded to any of the emails that Ms. Jordan or I have sent in an effort to have that subsequent conversation. So I'm not sure that I am, I'm not sure what you are asking of me, Delegate, essentially. If, these proposed amendments are, I don't have anything and no quarrel with Judge Morrissey's request, but this is not how we left that conversation. And it was you, Delegate Phillips, who said, let's split out persons eligible for relief under the statute from everybody else, neighbors, bar fights, anybody like that. And that's the premise that I was working forward from. And after conversation with Ms. Jordan, that's the premise that she and I were conversing about and came up with with the proposals that we subsequently sent that haven't been discussed at all. So I'm, I'm not, like I said, I am not sure where to go from here, because I don't think we've had a fair airing of what we were considering in light of that conversation we had on that phone call.
So, Mr. Chair, may I add to that a bit?
Sure.
Thank you. I was not at that meeting. I was out with some health things, so I was not part of that original conversation. But I do want to echo that the state's attorney's proposed amendments are not things that that were kind of part of the original discussion. And I will say, in part, it's far beyond the scope of either Ms. Ruth's or my client base. We don't represent neighbors cutting down flowers. We represent survivors of sexual assault and domestic violence. And so we really had looked at the concerns that we have about not having access to immediate arrest warrants, and the concern that, as Ms. Ruth had described, the hypothetical of someone showing up with a broken arm and her baby in her arms at 2 a.m. and being told, "Yeah, we'll get back to you." And that was really what we were trying to avoid. So from my point of view, the ability of the commissioners to immediately issue an arrest warrant is absolutely key. Like, that is the safety concern. I fully appreciate and have had cases where the system has been abused, and some of the things that we had suggested in order to address that included having the commissioners look at the history of litigation between the parties, and that if there were a protective order against the applicant, so somebody who has a protective order against them is trying to get charges against the person who is being protected by the protective order, that is something the commissioners should not be able to address, and that they should go to the duty judge, who is on duty 24/7. And similarly, if you have a situation where the applicant for statement of charges had more than 2 cases where charges had been issued against the same person and null prost, that again is something that is subject to review. And then additionally, for all of those other cases where there really is urgency, there really is danger, that we allow the commissioners to issue an arrest warrant, and that is the situation where the state's attorney would then review. And if the state's attorney doesn't get back, the arrest warrant stays in place. So those are the sorts of kind of balances and precautions that we were hoping that the subcommittee would entertain, and really, I think, have worked hard to try to find something that would balance both the emergency, dangerous nature of some of these cases and the genuine problems that we've seen with abuse. The last thing I just wanted to remind the committee, which I'm sure you know, is that police officers have the ability to arrest someone without an arrest warrant in that first 48 hours. So at very least, we would really urge the committee to make sure commissioners also have that same authority, because many of the clients I work with, they don't want to call the police. That is not their desire. They want the abuse to stop. They're being told to go to the commissioner. They prefer to go to the commissioner. But what we're considering now, taking away this arrest warrant authority from commissioners, would mean that they could go to a police officer and get immediate arrest, but they could not go to a judicial officer. And that seems non-responsive to the population that we work with.
Wouldn't it be possible for the commissioner to educate the individual that if they felt physical danger, that they could go to the police, particularly if they were harmed?
Well, the commissioners are not supposed to educate anyone. They are neutral judicial officers. So that is that is really not their role. And I would again say, with all respect, Mr. Chairman, that I don't think that responds to this population in Maryland that is in danger. You know, I spent a lot of my litigation career litigating in Prince George's County and in Baltimore City, and it was rare for me to have a client who wanted to involve the police. And whether that's good or bad or correct or incorrect, that's reality. And if we require that survivors go and talk to police, my concern is that they won't.
They won't.
And that we will then lose our opportunity to intervene in family violence and to help people become safe. And again, I would just urge the subcommittee to at least say commissioners have that first 48 hours to issue the arrest warrant, continue the review. You know, maybe if the abuse is 2 weeks ago, maybe then you do say, oh, we recommend an arrest warrant and it goes to a state's attorney. That sort of compromise, I think, makes sense. But just eliminating the ability to go to a commissioner in a state where that has happened for, I don't know, I think hundreds of years, I think that would be very abrupt and ultimately endanger our clients.
Got Delegate Embry.
Thank you very much. And I just want to make sure, we have the amendments? Did I miss? I looked, but I didn't see.
I don't think we have the amendments.
Okay. I'll just say for me, the details do matter. So I would really appreciate, once they're done, being able to look at them. 2 questions, though. One relates to this issue of like what happens. So whatever the time, 4872, if the state's attorney does not respond to the commissioner, does that mean the arrest warrant it comes to the commissioner can issue the arrest warrant if they haven't heard from the state's attorney, or does nothing happen? How is it written, or will it be written? Because, and then related to that, last year there were state's attorneys who said they don't have the capacity to do this. I understand that may be different this year, but it does make me worry that there will be state's attorneys who just aren't capable of doing the review and getting back to the commissioner, and whatever the time period is that we land on if we go that route.
If I could just respond, Lisa and I did not draft actual language because we were at a different stage of negotiation or conversation, if I could put it that way. So,
that was more for the bill sponsor, the amendments described at the beginning. Sorry.
That's totally fine. I just wanted to be clear that we have sent several emails with the concept and ideas that Lisa expressed, but hadn't gone so far as to draft any language because we weren't at that stage yet, in our view.
Got it.
Understood. Delegate Addison, do you want to address the issue of actually the draft amendments?
So right now, I don't think that we actually put that amendment in, but we will put that amendment, and we have constantly said up to 72 hours for this bill. But I do have Mr. Brian Levy in the waiting room if you would like to admit him, please, who is an expert on this and who is also helping.
And
Mr. Brian Levy is going to.
Oh, go ahead.
He's going to speak to the amendment.
I submitted the amendments to Delegate Emery, and I can, for anybody on the subcommittee, after speaking with the delegate and our conversations, we submitted that and drafted that, and I can send it to you, Mr. Chairman, and you can disperse it to all the delegates. I apologize if that hasn't already been given.
I meant formally drafted, like through DLS.
Yes, I think it was submitted, Yolanda, if I'm not mistaken, on Friday to DLS.
Oh, okay. Thank you.
Mm-hmm. And to your point, delegate, what you're asking.
But I don't know.
No. After the 72 hours, it would be a warrant issued. So it wouldn't just go away.
Okay.
So I want to be clear. The state's attorneys would be given 72 hours. If in fact the state's attorneys did not respond in 72 hours, a warrant would be issued.
If that's correct? The recommendation of the court commissioner. Correct.
Okay. Delegate McComas,
I'm
you
sorry.
had your hand up. No, go ahead. Wait a minute. Hold on.
I'm sorry, would
Delegate
you mind,
Embry, did you have-
Chair, if I could just be clear? So the commissioner either drafts a warrant and then sends it for review, charges in a warrant and sends it for review, or they send charges and recommendation for a warrant for review. If the state's attorney reviews it and says no, then the state's attorney could say, right, they could say nothing at all, we don't think this is viable, and then nothing, no summons, no warrant. Or they say, please just issue a summons. Or they say, please issue a warrant. Those are the three things that could happen. And then if they don't do any of those things, the commissioner, that warrant would go out. Is that correct?
That is correct.
Okay, thank you.
Mhm.
All right.
That is only in the case of
Delegate
domestic violence.
McComas. Thank you for
And
your
for that-
patience. Only in the case of domestic violence. So that warrant would be issued, as I understand, under the proposed amendment that we haven't seen. The proposed amendment, it would be only in the case of domestic violence that we would take a different path.
Correct.
Right. Delegate McComas.
Just briefly, my concern is I see where the domestic violence advocates are coming from, because a lot of times you don't know the heart of the the person that the victim is complaining about, and a lot of times because it's interpersonal, it can become like a flashpoint and very volatile very quickly. So I was wondering what other states do, and maybe Delegate Addison could contact NCSL and see if they do discriminate between, commissioner issuing something on a domestic violence right away, or if they have a state's attorney or a police officer look at it first before they issue a warrant. Just kind of see how the other states do it to get a feel for, and certainly we probably should hear from the experts as well, but they can be very, very volatile very fast. And that's a real concern, and 72 hours can be a lifetime and be a game changer. So I have a concern there, and
Yeah.
having dealt with my first case that ended up on the front page of the Sun a long time ago, hostage situation, guy ran through the window, got the gun from his brother. That's kind of scary stuff. So just kind of want to throw that in, that's a concern, that things can turn south real quick.
So let's I'll let you directed that question to Delegate Addison, and so if she can answer that question, we'll allow her to answer that question. I see a hand raised from Ms. Hilliard from OPD. And Ms. Hilliard, I'm assuming you want to chime in on the question that Delegate McComas asked?
Yes, sir. I'd actually ask that Brian be allowed to answer because he's done research on what other states do.
Hi, my name is Brian Levy. Do you want me to speak now?
Go right ahead.
I don't have a case-by-case study, but I'll tell you the majority of states do not allow our system where charges are being filed with no screening process at all. The far more common situation in states that allow anyone to go and apply for charges is that those charges would be referred to the prosecutor's office or the state's attorney's office for review to determine whether a case is viable or not. And frankly, I think that is the direction we should go as well, not just in terms of cases where warrants are being applied for, but all cases, because even if cases that don't have warrants issued, there are immense collateral consequences of being charged with a crime, even if a warrant's not to immediately issue. And we shouldn't be allowing charges to go forth without an investigative body here, the state attorney's office, looking into the case to see whether it's in fact viable and whether their office wants to go forward.
Understood. So let me tell you where I think most of the, well, I won't say that. Anyone else have any further comments? We probably will not take this to a vote today. As I'm listening to some of the comments on all sides, we will meet again. And we need to have the actual amendments in the members' hands. So I will tell the sponsor, I need the amendments in the members' hands as soon as you can get them to us, and so that we can have a true review. If there are additional amendments that any of the parties on this call, on this work group would like to offer, if you could get those to us, and I'll say within the next 48 hours, I'm going to talk to the chair about potentially doing another subcommittee meeting specifically to deal with House Bill 336 before the end of the week. From the chair's perspective, this is an issue that we need to address, and we need to address it this year. And so I don't want a lot of time to pass on this particular matter. All right. Any other comments from any of the delegates? Any delegates have any other question of any of the stakeholders? Any delegates have any questions of any of the stakeholders? Okay. Well, that will close the hearing on HB 336 in this work group session. We will come back to this. We will inform all of the interested parties. I will say to you when we come back, once again, please send your proposals. We're going to narrow down the number of stakeholders in the next conversation. You will each have someone to represent your perspective, but we're going to narrow it down so we can get this one resolved and out before the end of the week. Okay? All right. Thank you. All right, we're going to move on to House Bill 450. So if we could, those who are not on 450, if you could drop off, we'd greatly appreciate it.
Thank you. Have a good day.
All right, Theo. I think we have a couple of people that wanted to come in on House Bill 450.
Yes, Chair. I just included Delegate Guyton and their advocate, Debbie Feinstein.
Okay. Delegate Guyton?
Good afternoon.
Hey, how are you?
I am doing well, thank you.
My fellow Baltimore County delegate, we appreciate you joining us.
Thank you for the opportunity.
Yep, if you want to give us just like 60 seconds on what the bill does, just as a reminder for my colleagues.
Sure thing. I'm happy to be able to report that this bill actually mimics very closely your bill, Mr. Subcommittee Chair, from a few years ago that protected the privacy, the identity of sexual assault survivors and victims who were under 18. This bill expands that to those who are over 18, both sexual assault survivors and also survivors or victims of stalking. It's as simple as that. And I'm happy to let you know, you may already know that the Senate JPR passed this out on Friday.
Very good. Does anyone have any questions of the sponsor? Anyone have any concerns for the sponsor? All right. Delegate McComish, were you raising your hand?
Just a real quick question for Delegate Guyton. I assume that your bill conforms to the Senate bill. Exactly.
Yes, it does. There are actually, if you don't have them before you, you may. There are actually some Senate amendments that they had written and had voted in conceptually on Friday. And so they were working on the very final language for that, but I'm more than happy to conform directly with the Senate version. And I believe that your committee either has those or is about to have those.
Great, great. Kumbaya, right? For
Kumbaya.
once.
All right. So since I don't think we have them yet, Delegate. I don't see any opposition. We won't be able to take a vote until we have the amendments. So we will hold those until we have the amendments, unless you want to share something else. Was there any substantive amendment? You're talking to
All right, I'm
me?
sorry. I was just asking my staff, you have amendment by Senator Love that just hasn't been finally approved on the other side as being written exactly the way they want. But the substance of the amendment really dealt with a few of the pieces of testimony that you heard from the medical boards that wanted to have access to some of this information so that they could discipline members of their profession if they had actually committed a crime of this nature. And so that is really what these amendments apply to. It allows on the motion of the state or a victim or a witness to allow that information to be, excuse me, to be disseminated to those groups. But in order for that to happen, they have to make a compelling evidence to the court. And the court will also let the witness, the victim know that that's happening, so that if they choose to not participate in that or they choose to not have their information released, they can do that.
Okay.
Mm.
All right. Allow us to get the amendments.
Sure thing.
Once we have the amendments, instead of taking a vote now and getting amendments later, we'll take it all up at one time. Okay?
All right. Thank you so much.
All right. I don't see any opposition, so we're gonna move on from there. And I lose my notes. I did our last bill. I don't remember what our last bill is. Now I can't get to my notes. $566, House Bill 566. And this is Delegate Martinez. Is Delegate Martinez?
Hey, good afternoon, everyone.
Good afternoon. How are you, sir? All right, 60 seconds on what the bill does, just as a reminder to the committee.
Yeah, no, thank you all again. So House Bill 566 is criminal law distribution of students' personal information prohibition. It essentially establishes a anti-doxing anti-doxing law within our statute for students. We feel like right now free speech is really vital to protect, particularly on our campuses, and this is one vehicle we feel like we can do that in protecting the identities, the personal identification of individuals, because we've seen an attack on individuals online, in particular, when they express just viewpoints that maybe counter another person's. And so this is a way we think that we can help protect our students.
Any questions for Delegate Martinez? And I don't believe anyone requested to sign up in opposition. Is that correct, Theo?
Yes, Delegate.
All right. All right. And no questions for Delegate Martinez? Going once? Oh, there we go. Delegate Embry.
I'm so sorry. I'm not, I don't have my floor system. I'm trying to just remember the unfavorable. It may have been written. I just don't, I'm so sorry. I meant to have it with me for this hearing, but
Yeah, hold on a second.
I think there was a question about, was harm sufficiently defined? I'm not saying it was right or wrong. I just don't remember.
Hold on a second. The unfavorable was from the Maryland Office of the Public Defender.
Okay.
National Association of Social Workers and the Maryland, the Office of the Public Defender. And the Office of the Public Defender basically says that the bill was well-intentioned but could be used to prosecute the same individuals who we're trying to protect.
Okay, I appreciate it. Thank you, Chair.
Had you, Delegate, had you spoken with OPD since your hearing?
Not, no.
Okay. And apparently OPD did not indicate that they would like to be heard on this today. Any other questions for Delegate Martinez? Yeah, Delegate Embry.
I'm sorry to monopolize, forgive me. So just on that point, so as I read it, so reckless disregard for the risk that it could be used, I wonder how we would distinguish that. So I'm just trying to think through, we have people who feel passionately about an issue, right? On both sides, and they feel that it's important to identify the people involved on the other side, as you know, we all understand why people might feel that.
Mm-hmm.
So if they put the person's name, you know, they say this person supports X, and they include I think, yeah, their name and maybe where they work. How would we establish the reckless disregard? I mean, if they're, how do we know they're not just trying to say, world, I think you should know that this person supports X because I, you know, strongly oppose X, and it's outrageous to me that this person would support it. And then it's used, someone uses it to, you know, I guess doxing is the primary issue. So other people then,
Right.
you know, repost it, retweet it, whatever. How do we establish that reckless disregard? Because I could just see that, you know, happening, obviously, in a prosecutor evaluating that circumstance. So that's my question. I'm sorry, it's convoluted.
And to your point, so this is I'm going to read it because
Yeah.
this is the scenario that they speak of in OPD. Imagine a scenario where a student is running for president of student government. The candidate openly discourages the establishment of a whites-only student group and argues that the student association, based on national origins other than American, should be prohibited. A fellow student posts a video on their personal social media page using the candidate's name and photo and comparing the student's candidate's position to segregationist. This law would enable the student candidate to file criminal charges against the social media poster. And it goes on. While the statute has a mens rea requirement, the state must prove at trial that the person intended to cause harm or had reckless disregard that they would such a requirement does not prevent prosecution. So I get it, and I'm wondering if there was some way to narrow this. All right. Delegate, I think we're going to have to do some balancing on this.
No, that makes
And
perfect sense. I think for me, the intention is just making sure that we are modernizing our statutes to meet the realities that are at play. I think the OPD example, what it lacks is the intentionality to cause harm, right? Like you can post someone during a student election saying, this is what I believe they're saying equates to, without necessarily identifying where they work on campus, where they live on campus, where, you know, these other key identifiers that would allow for someone to then take it another level. I think that's what we're seeing is a lot of threatening around just these clear identifiers to say, hey, this person has X belief. Here's all the information I can find online about them, and then take it as you will, understanding that there are bad actors out there that could take that information and harm someone. I think the question then for the committee then is how do you balance that reality versus kind of anticipating what someone's intentions are? And I do understand that. I think this is just my best attempt at trying to codify something, but I'm open to ideas of the committee on how we can move that forward.
got it. Thank you. Thank you. Any other questions for Delegate Martinez? So in essence, we don't want people to put information out there that would cause other people to want to harm them, and to provide them with the means, the mode, and the method. All right. Allow us to take a look at this. I'll review it, and I'll review it with committee members to see if we can. We understand the intent.
Thank you, Mr. Chair.
All right. All right. Well, we've heard 3 bills today. I actually thought we might get to vote on at least 2 out of the 3. It looks like we still have some additional questions and additional work to do. I am going to ask the chair if we could meet again before the end of the week. There's some real date problems or time problems this week, please let me know. We may be looking at Friday if we can squeeze it in. Okay. We heard today. Can you please see me either the suggestions or recommendations? I actually think all 3 of these bills as proposed have real value to the citizens of Maryland. They are now our work product. So let's see if we can bring them to resolution. All right. Very good. Well, that will end the work of the Criminal Law and Procedure Subcommittee for the day. I will see you all on the floor this evening.